Good morning. 2 seconds. Vertically challenged, so I'll bring it down a little. Can your honors hear me? Okay.
Yes.
My name is.
I'll let you know.
Okay, awesome. Thank you. My name is Megan Powell. I'm here on behalf of the appellant Jesse Carl Smith, and may it please the court. We're here today to determine whether the sellers of a property adequately disclosed two specific conditions of the property. One of them was the extent of a 2020 flood that occurred at the property, and one is the flood history, which includes that the property is a severe repetitive loss.
Let me just, I hate to just stop you right at the
That's
beginning,
okay.
but in thinking about your arguments, I get the non-disclosure of the flood history, like why that would be problematic. I'm not as clear about why the extent of the damage from the 2020 flood is problematic.
I can answer that from a conceptual standpoint and from a personal standpoint, which is, I don't know how many of you have had a flood at your house. It's traumatic, to say the least. And I think the fact that this 2020 flood occurred was disclosed. Obviously, it said that there was a flood in 2020, slight
There was
damage.
a flood.
Right. The problem is,
And all the damage was remediated.
so it said all the damage was remediated, so there's no lasting physical damage. I agree insofar as that's the truth, right?
Right.
However, the fact that the 2020 flood caused catastrophic as opposed to slight damage is an important factor for a buyer to know, especially when you view it in a light of, in addition to the 5 prior floods, because we've got 5 floods on record that required a flood insurance claim to be placed because the damage was so bad that an insurance claim needed to be placed. And then we've got the fact that your house could flood repeatedly at that amount. $33,000 of damage to the property, plus an unknown amount of full contents damage, is foreshadowing for the kind of flood that you might experience at the property. So, and I'm not suggesting that the seller should have said, oh, we experienced $33,000 worth of damages and we experienced full contents replacement. What I think would have been adequate under the seller's disclosure would have been to say there was a flood in 2020, insurance claim was placed. At that point, I think that representation would identify to the buyer that maybe there's some kind of an investigation that needs to take place and maybe they can ask for the insurance information. There was not even a notice that an insurance claim was placed.
He knew it was a flood zone.
Certainly, yes, it's
And because they got an estimate on flood insurance.
right.
If I'm understanding the record correctly, when the Lynches were looking at buying this property and they got the information that it was in a flood zone and they were looking at flood insurance, they also got the seller to provide them with the flood history.
Yes, this is because
And they knew that that was something that was available. The Lynches knew this, and they knew that it was only available to the current property owner.
yes, correct.
But they did think to ask for it.
They actually didn't think on their own to ask for it. If the court looks at the information provided by Mr. Della Costa, which is what you're, so what happened was Mr. Della Costa assigned his insurance policy to the Lynches when they were the buyers. So their insurance company was provided the information that this is a severe repetitive loss, and then the realtor told the Lynches, and based on the email between the realtor and Mr. Della Costa, the Lynches became concerned after learning of this, after getting assigned the insurance policy. I know it's a little confusing, but if you look at Mr. Della Costa's email, which he swore to in an affidavit was an accurate representation of his memory, he explains that that's the version of the events, that he initially discloses the flood that occurred when he was at the property during a different tropical storm or hurricane. Then he assigns his insurance policy to the Lynches, and then they learn about this designation, the severe repetitive loss designation. They then say, hey, that concerns us. Realtor, find out more information. Realtor inquires with the insurance company, and they say, only the homeowner can get that. So they ask Mr. Della Costa to get the information from FEMA, which he does. And then he supplements and revises the seller's disclosure to include not only the flood history, which was not provided to Mr. Smith, but also a description of the pump system that was in place in the backyard that nobody ever told Mr. Smith about to mitigate the potential flood damage of these repetitive floods. So that's how the Lynches found out. I hope that answers the court's question.
Yeah, I think I understand.
Okay, so I want to go back to the 2 lenses that we're here under. We have the fact that we're arguing that not only the court shouldn't have granted summary judgment in favor of the Lynches, but also that the court should have granted summary judgment in favor of Mr. Smith because it was competing motions, cross
I've
motions.
got a quick question about kind of the legal
Sure.
area. So I'm not sure I read Johnson v. Davis as creating a standalone, independent cause of action. I don't think it does. The cause of action in Johnson was rescission. Here, you're suing, I think the flag y'all are flying under is fraud, is that correct?
No, so the fraud and the inducement is an alternative count.
Okay.
I've seen a lot of courts, so Johnson v. Davis, they call them Johnson v. Davis claims, but they typically arise under a breach of contract or a rescission because the Johnson versus Davis disclosure requirement is actually a creature of contract law. So it may be labeled as a Johnson versus Davis case, but really it's a breach of the contract which requires a full disclosure of the conditions.
Okay, so
Under
that's what, when the fraud and inducement is the alternative.
Yes,
Breach of contract is what you're flying under. Because Johnson v. Davis doesn't purport to create an independent cause of action. It just says you can't caveat emptor out under these certain kind of scenarios.
correct. And it also provides the standard that we review these sellers' disclosures under to make sure that they were adequately done.
So that segues into what I'd like to hear your thoughts on. Usually, and I'll just call them Johnson v. Davis claims, even though that's not a standalone cause of action, but usually it's a situation where we see there's some material condition that affects the house or the property itself in some way. And that includes even in the case, I think it's the Revitz case,
Revitz versus Terrell.
right, where there may not have been an actual physical condition, but it was built according to code. Right, so you could, like, literally, you had a code violation that you were buying into that it looked like the seller knew about. That's not really what we have here, because you're not suing because of any flood damage to the property. You're not even really suing because of the propensity to flood, because again, you knew it was in a flood zone, it's on the bay. Rather, you're suing solely on the discrete issue that flood insurance costs more than what we were anticipating. Have you found it? I mean, that's kind of how I'm reading what's left of your claim.
I've got a couple of different responses to that. Number one, the damages in this case are not just that his insurance policy is more expensive. That is certainly part
The
of,
reduction in property value.
Certainly the
ability
reduction.
To sell the property in the future.
exactly, the fact that an identical
Of course,
property.
he can just not disclose all this history.
I'm sorry?
Of course, he can just not disclose the history.
Although he would open himself up,
Yeah,
he would open himself up to liability if he did not disclose this in the
Right, right.
future. So he's going to have to disclose it if he wants to sell the property.
The Smith's book.
Yeah.
And Lynch's book.
An identically built house next door that doesn't have this problem is going to be worth significantly more. That's what some of the case law, Revitz included, talks about, is that the materiality of a condition is subjective based on how it affects the buyer and how it would have affected the buyer's choice to purchase the property. But I want to go back quickly to your question, which if you could remind me, it was about the damages, correct?
Yeah, I mean, just to the extent, insofar as you're seeking damages because of this debate between what you now have to pay for flood insurance versus what you thought you were going to have to pay going into it.
Okay.
Is there a case that kind of stands for that proposition that, hey, getting tagged with a higher insurance bill, yeah, that's material enough in and of itself?
Certainly, it's the Revitz case, in fact. I understand that that has a physical component, but
It
this is
definitely does.
this is certainly not just, this is a physical and a conceptual component in this case, because we've had 5 prior floods at the property,
Yeah.
which allows you to foresee what experiences you were going to have in the property.
You had a case where like the buyers looking around and saying, wow, all these other houses are built on stilts, why isn't this one?
Right, but I would
Oh,
also
it's fine,
point,
it's fine, I don't worry about it, don't worry about it. I mean, you can kind of conceptualize that a little bit easier under Johnson v. Davis.
I understand. I would say that there's not a single case out there that restricts Johnson versus Davis claims to only physical conditions, and that I've found in my
But, you know,
research.
I see Judge Lucas's point about, because I sort of felt the same way. And I think maybe by, you know, that's one of the reasons that the Lynches have tried to recharacterize your claim. Because you've relied on Johnson, so, okay, we'll make it about Johnson, this, you're not disclosing this is a flood area, but it's obviously a flood area, you're on the bay.
Right, but that's not what the allegation is. The allegation
No, I
is,
know,
yeah.
but I wonder if by, bringing Johnson into this, you haven't sort of invited them to recharacterize your claim the way they have.
I disagree just to the extent that the condition, ignoring the fact that the property is located in a flood zone. It's flooded 5 prior times
No, I mean,
catastrophically.
I'm clear about what your claim is.
So,
But that's, I'm also agreeing with Judge Lucas that, meshing that with Johnson versus Davis is, it doesn't seem like a great fit.
yeah, I understand, but I would also say that under the seller's disclosure form, which was designed to help people comply with their Johnson versus Davis disclosure requirements, there's also requirements on there that you disclose if there's a lien on the property, if there's other conditions like lawsuits involved with the property that are not physical conditions of the property. So I think the idea is it's anything that materially affects the value of the property.
This undoubtedly materially.
Exactly.
affects the value of the property.
And I think the reason that we went to the seasonal flooding and the flood-prone area is because of this Nelson versus Weeks case. Also, if I could interrupt my own self, I wanted to reserve at least 2 minutes for rebuttal, so I,
2? Okay.
yeah, so, or 2
All
or
right,
3.
you're good, you're at 11.
Okay, awesome, thank you. I think that the court improperly relied on Nelson versus Wiggs as if it was it's weird because it's as if it was a binding precedent, but interpreting it in a way that is not how it is supposed to be interpreted as well. Obviously, I provided the court of Nelson versus Wiggs to the court. And the trial court in this case said that pursuant to Nelson, a seller of a property is not required to disclose the flood-prone nature or seasonal flooding at a property that is in a flood zone, essentially. That's not what Nelson said at all. Nelson was a case-by-case analysis, as with all Johnson versus Davis cases, where the court was looking at, under the circumstances of Nelson, was the condition, which was the seasonal flooding, observable to the buyer, right? That was really the only question that the court in Nelson went into in depth. The facts of Nelson are completely distinguishable.
Well, that's not what you're talking about here.
Sorry?
And that's not what you're talking
Exactly.
about.
It's not even, I can understand why it seems related, because a property that flooded might be located in a flood-prone area. But whether the property has flooded or not has nothing to do with whether a location gets seasonal flooding, right? Lots of houses in Pinellas County are in flood zones. Most of them, I would say. A lot of them, I'm sure, haven't flooded. My house is not in a flood zone. It has flooded. So the point is, there's a distinction between seasonal flooding and disclosing 5 severe prior floods and a special insurance designation that makes it so that your property is worth substantially less than.
Was that a new requirement that the insurance companies would check out the rates recently based upon insurance requirements in the state of Florida?
As in, do they have to double check with FEMA whether it's a severe
Well,
repetitive
in other
loss?
words, but for the insurance increase, we wouldn't be here. That's the main contention that the buyers have.
No, that was the contention that he had before learning more information. When he was in pre-litigation, that was what caused him to start investigating further what he learned. We're here because the property.
You didn't have a current flood.
No, well, it's not in the record, but there has been one,
But
so.
it's not to be an act of God. You're limited to future potential losses based upon his increased premium. The premiums have gone up all over the country on waterfront property, and they have a Florida bar as is contract. How does that factor into the equation?
Because in this case, it's not just the insurance premium. Number one, he paid more for a property than he would have paid or bought a property that he would not have bought if he had been told the truth. So there's the damage of he's overpaid for the property or bought something he wouldn't have bought. It's a significant investment.
But he wasn't told there was no prior flood history. He was told, we had a flood, we took care of it.
Right, and that's
And
the
there was 4
problem.
more prior to 1982 with different owners.
Sorry?
There was 4 more floods prior to 1982 under different owners.
I think it was between 1982 and 2020. I don't think it was prior.
Prior to the sale.
Yeah, so the thing about this is that it's a partial disclosure that minimizes not only the circumstances, but the damage as
Well,
well.
that's part of your argument too, right? That if this isn't really non-disclosure, they actually misrepresented.
Certainly, yeah, and
And
it,
that changes the dynamic in the analysis.
yes, so depending on, and that goes to the observability requirement. So whether the buyer could have observed the condition. The buyer has certain responsibilities to investigate things that they learn in a sale. However, if it's a fraudulent misrepresentation, there is no responsibility for the buyer to investigate the information. If it's a negligent misrepresentation, they have to do ordinary diligence, so they liken it to a one-eyed horse. If you go to a horse show and you buy a horse, and you go home later and say, oh my gosh, the horse has one eye, I want my money back, you can't complain that you didn't see that the horse had one eye,
Right.
correct? So in this case with the house, I liken that to, if you go to a house, the windows aren't impact rated, you can see they're not impact rated, and then a week later, you're like, man, I really wanted impact rated windows, I want out of this contract. That's something that any inspector can see. In the negligence circumstances, your diligence, essentially the case law tends to agree that if you've gotten your inspection and you've basically looked at the property, then that's sufficient. In addition, even if Mr. Smith was in any way negligent in trying to determine this information, the case law has suggested that that's not something that can get rid of his claim entirely. It's something that should be deducted from his damages from a comparative standpoint of his amount of negligence. And I can find the case on that if the court would like to see it. But in terms of the actual observability of this, I think we also provided significant evidence that only the homeowner can get this information, at least with respect to
Well,
the,
yeah, and the Lynches knew that.
yes, and they knew that because of their conversations with Mr. Delacosta.
They knew the history, and they knew that the buyers couldn't get it.
Right, exactly. And they thought it important enough that they were concerned with getting the information, and they got a revised disclosure
Yeah,
with that
I
document.
think they understood that it affected the value of property because they didn't disclose it.
Right, and in terms of the 2020 flood, I understand.
Well, if they'd asked us, we would have told them.
Exactly, so they've actually never, despite providing an affidavit in support of their motion for summary judgment, denied knowing these things. The attorney made passing comments at the motion for summary judgment hearing that there was a question of fact as to whether their agent relayed that information to them, but they didn't actually present any evidence of that, and that would also concede that there's a question of fact and summary judgment should have been granted, but the point is, they've never refuted that they actually knew, and in fact, they said that had Mr. Smith inquired further, they would have provided more information. I think the fact that it was important to the Lynches is hugely telling in the fact that would have been important to Mr. Smith. So I'm gonna reserve the rest of my time, but I just wanted,
3 minutes.
oh, thank you. I just wanted to note, there's some really powerful language in the case law about the Johnson versus Davis cases. It says that the practical effect of Johnson is to encourage full disclosure in those transactions where a seller might be in doubt as to whether a set of facts should be revealed to a potential buyer. So in this case, considering it was a question to the Lynches, I believe it falls squarely within the type of information that should be revealed.
Thank you.
Thank you. You're so welcome. Also,
I'm challenged here. So I was going to start with the fact that this was a readily observable, diligent
No, no,
attention.
Don't, I want to stop you right there because one of the things that concerns me about your argument in this case is it really doesn't address what they're alleging. I mean, everybody knew it was a flood zone. Everybody knew it. They went, so that's not the issue. What's not readily observable is the flood history that the Lynches knew was only available to the property owner and kept to themselves. And I don't really see how you've addressed that.
Your Honor, I think there's two things I will say about that. One is about the 2020 flood, which was the one that happened when the Lynches were on the property. And I would like to quibble with the notion that they didn't make an adequate disclosure of that because they said, they characterized it however the exact words were, but it was about a $30,000 damage. And so my question about that is that I'm looking for, there it is, definition of slight. They said slight damage.
Here's what they said. They said 2020, they checked the box.
Yes.
They said, yes, there's past water intrusion. And under subsection G, they handwrite 2020 slight water damage to carpets. Water on garage floor, all was cleared and repaired.
Right.
Forget that last line, but the slight water damage to carpets, that is an understatement,
Yeah.
correct?
Your Honor, I don't know the extent myself of what the damage was. What I'm quibbling with is the characterization of it as being an inadequate disclosure that if Mr. Smith had said, well, what do you mean
You
by
have to rip out drywall, if you have to remediate baseboards, if you have to take up everything from the ground up to 9 inches, that's not slight water damage to carpets.
Well, he certainly could have asked and they would have talked to him more about that flood.
No.
All right, well, let me go then to what you asked, Your Honor, more particularly.
Yeah,
the
what I
flood
just want to
history.
ask you is your position that a property owner selling their house who is well aware that it has a serious flood history, multiple floods over a period of years, they've gotten the flood history, is your position that there's no obligation to disclose that?
I don't think the record reflects that my clients were,
No. Let's assume they did know.
or were just
So you're
assuming.
saying there's no obligation to disclose this flood history?
If in fact, the landowner, property owner, the sellers, if in fact the sellers had the past history in their possession, they remembered it from when they closed however many years before, they failed to disclose it intentionally, yeah, that could be a problem. But how about,
So why don't we have a fact issue?
well,
And
because,
also, what about the fraudulent inducement claim? I know I'm throwing a lot of questions at you, so answer however, in whatever order you want. I'm gonna be quiet for a minute.
okay, well, it's my job, so throw anything you want at me and I'll do the best I can. But I think that what the trial court focused on is what was the evidence presented to the trial court in forms of affidavits and otherwise. And our client did not, the buyer did not investigate the flood prone nature of this property. That was clear. He was told it was flood prone. The public record.
Well, okay, you went to a flood insurance company and got an estimate.
Yeah, he sure did. That's right, and he could have inquired from them, is this gonna go up next year? Does this go up every year? How bad am I getting into this? Because
He could have gotten the flood history, could he?
he could have asked my clients, the Lynches, for the flood history, or to get the flood history, especially if they didn't have it.
Clear one thing up, was there a dispute or an acknowledgement that your clients actually knew the prior history, the 4 previous floods? Did they get the information from FEMA before the lawsuit began?
I don't know the answer to that, Your Honor,
They
because
had it before they purchased the house.
So
that's right,
Yeah.
So they had all the information.
that's according to the seller who sold it to the Lynches.
Seller that sold.
That he provided that
So the
information.
people that bought it from the Lynches could have done the same thing, but they didn't.
Right. That's true. And Mr. Smith could have asked them.
History, when you have it. They didn't know it'd be one thing, but they did know. They deliberately didn't tell them anything about the 4 previous floods, but only their own flood that they had.
If Mr. Smith had done just a minimal investigation, he would have found things in
Here's the problem with that, though.
Mhm.
To some degree, the Johnson v. Davis disclosures that have kind of come up and are required, the idea is that it's supposed to put the buyer in a position where they know things that the seller is aware of and that they can't necessarily get on their own. I don't really think there's a dispute that the seller was aware that this property had flooded in the past, in addition to 2020. My problem is that when you actively make a representation and it says 2020 alone, not that there are 4 or 5 instances of flooding, just 2025 itself, and then says it's just slight water intrusion on the carpet, that can be read as an affirmative representation. This is as far as it's gone, and
Yeah.
and I've signed this, and look, here's even a footnote that says Johnson v. Davis on the paper that I'm signing off on. Yeah, you're good, you can take that to the bank. That's a problem I'm struggling with, is that the actual disclosure that they gave may have been itself a misleading representation. Help me with that.
Well, Your Honor, I think that the evidence is lacking that my clients, that the Lynches had that knowledge still in their minds, and it was given to them when they bought the house, which was years before, or that they had a file somewhere where they could have dug it out of. What they got was the prior seller.
But the judge tells one, I mean, isn't that something that a jury should sort through? Because this
We
gets
think-
resolved on summary judgment, right?
So we think it's a little bit unnecessary here for a slightly different but very similar reason, which is that Mr. Smith's complaint was that he had to pay more for flood insurance. And he was damaged, as his language put it, $5,000 a year into the future every year. I don't know where that number came from, but other than the year, 2 months or so after the closing, that's what it went up to. But the point, I guess what I'm saying is that he was focusing on and claiming his damage was the increase in flood insurance and my client premiums. And my clients are saying, we're not guarantors of flood insurance premiums. Who knows what?
But he's also saying, I wouldn't have bought the house if I'd known this.
Well, he might have been saying that, but in the sale contract that he signed, there's a provision, disclosures, flood zone, elevation certificate, section 10D of the sale contract that specifically says if the property is in a quote, special flood hazard area, close quote, then the buyer can walk away. Don't get your money back.
Instead, he contacted a flood insurance company or insurance agency and got a quote on flood insurance.
Right, so
Okay, that's
that's,
different than knowing this has the kind of flood history this house had, which then made FEMA give this designation, like 1% of houses have this designation. I mean, that's not, to me, that's materially different than knowing this is in a flood zone. And getting a quote on flood insurance because, yeah, I know it's in a flood zone.
even the public record warned him. I'm not sure how much you have to warn a buyer before the buyer is responsible for his own
I
actions.
want to go back to Judge Lucas's point, which is, they disclosed that there was this, in 2020, there was this event and it was minor damage. And they make the point in their argument about, you know, if you say nothing, that's one thing, but if you make a misleading representation, that's a different thing.
Well, they disclosed a little more than that in the seller's disclosure. They disclosed there had been past or present water intrusion, past or present issues with drainage. There was flood insurance required on the property. They attached the elevation certificate, which put Mr. Smith on notice if he hadn't noticed yet.
I don't think there's any question they didn't know all that. But I guess, you know, I'm a broken record. I'm really hung up on the fact that the sellers knew about this property's history. And I think it's fair to say they misrepresented it in their disclosure. At a minimum, they didn't disclose it, but I think it's arguable that they misrepresented it. But I want to go back to a question that I threw out at you with a bunch of others, which is, I want to talk about the fraudulent inducement claim and why that was, what again is your basis for saying that that was proper for summary judgment?
Well, there was no evidence of fraud in the record that the trial court could have relied on to say that the Lynches, whatever they did or didn't do, had done it intentionally and fraudulently.
Intent is usually a factual issue.
Why isn't that a fact issue?
Well, because you have to have some evidence, don't you? I mean, you can't get to a jury or a judge on a trial without
We
some
know that when they
evidence.
bought the property, they had this information. And we know that they made this representation that there was a flood with minimal damage in 2020 and not, oh yeah, and there's this. I mean, why isn't that, you know, and the Smiths are saying we wouldn't have done it if we'd known this history. Why isn't that the guts of a fraudulent inducement claim and at least enough to get you to a jury?
I think what Mr. Smith said was, I wouldn't have bought the property if I knew my flood insurance premium was gonna go up. It's a different cast on the case than the court is seeing. He
Okay,
didn't
but
say,
that's,
I don't
that's
want
beside the point. I mean, you're not answering why that isn't enough, regardless of what he says he would have done. Okay, I wouldn't have bought it because my flood insurance, whatever, he wouldn't have bought it. Why isn't that enough to get the fraud, at least the fraudulent inducement claim in front of a jury?
Well, Your Honor, I think it's simply because there's no evidence that presented in that scenario that the Lynches did anything intentional. They gave him,
Well, again, you're back to intent, which I think we all, you know, would say, I don't want to beat you up, but I mean, that is traditionally a jury question.
And maybe he wins, maybe he loses, maybe the jury buys that, you know, they believe that, yeah, no, they were unaware of this, they did the best they could with the information they had, plaintiff go ahead without day, but to resolve this on summary judgment, on what sounds like your argument is that, well, there really wasn't enough there about intent on the fraud inducement claim, it's a little troubling.
well, I think we just heard one of the court is looking at it, and I know who wins that one, so. But I can't really give you any more of an answer than I have, that, you know, I'm going with what's in the record, and then how the case was cast at that time, and I think that's something important not to lose sight of. The complaint was, I get these higher premiums, and more
Well,
so.
and I can't recall looking at the pleading, but did they also seek diminution in value of the property, you know, diminution of resale? Or did it just say, you know, in the complaint, in the pleading, wherefore, as the beta between what we gotta pay on insurance for auxiliary?
Yeah, I want to be very.
Or are you just kind of extrapolating it based upon negotiations and letters that come back, which are two different things?
I do want to be very candid with the court. I can't tell you
Okay.
if the complaint says what you're asking or it doesn't say that. But what I do know is, for example, Mr. Smith's affidavit in opposition to summary judgment, or maybe it's in support of both because they were competing motions, did not talk about that. It talked about the increased cost of the flood insurance premiums, and that if he had known it was going to get so expensive, then maybe he wouldn't have bought. Well, like, the sellers aren't guarantors of that, and they had no way to know. And in fact, they didn't make any representations to Mr. Smith, which is Mr. Lynch's affidavit, about the cost of flood insurance. They certainly told him he was going to need it because they needed it, and he would need it to close. He did not avail himself of the opportunity to back out of the contract, which that provision I was reading, 10D, gave him when he found out that it was in a high-risk area. If he didn't find out, it was his own fault because it was right in the public records. The listing for this.
Wait, excuse me, what was in the public record?
The fact that this property is in a high risk for flooding area. This is, I'll tell you where.
Are you referring to the AE designation?
The AE designation and just a little bit more in the listing for this property in Realtor.com, which is online. You could have, you know, searched it and got it. It was attached to a motion for sanctions that's in the record in Composite Exhibit A, to a motion for sanctions. The Realtor.com listing says the home is located in a FEMA flood zone AE, quote, within special flood hazard area and indicates high risk, close quote.
Isn't that generic though to just any AE designation, or is that?
But there's some more. I'll read you the rest.
Okay, go ahead.
The home is flood factor 10, which I assume is the worst. I don't really know, frankly. And, quote, flood risk is increasing as sea levels rise and weather patterns change. I mean, that, just, to me, just that listing,
Oh, no, that's not true.
that sea levels are rising.
Yeah. Sorry, that was an editorial comment.
Well, I guess my point about all that is that if he had even just done the minimal Google, I mean, everybody knows how to Google search, right? And read that, wouldn't that make a reasonable person say, I should really better find out more about this flood insurance issue that I'm worried over? He had an agent, he had a real estate agent as well, but he had an insurance agent. And he had an inspection done of the property, and after all of that, he said, I'm waiving, my inspection period, and I'm gonna buy the house, and he closed. So we think that the trial judge was right, because when you take all the facts and you put them all together, the nature of the property was easily accessible and obvious, and the fact that premiums go up is certainly not on the seller. So we think the trial court got it right and should be affirmed. Thank you.
Thank you. All right, we've got 10 minutes.
Thank you. Keep it very brief.
Let me have you pick up
Sure.
where Ms. Tomasi left off, which is, actually, there was a lot of information out there that might have set off an alarm bell in Mr. Smith's head that I better investigate further. And, I mean, the Lynch's thought to do that. Would you respond to that?
Certainly.
Especially, things like she said, you can Google, there's plenty of, even if you can't get the flood history. Wasn't there enough there that maybe he should have investigated further?
So a couple things. The Lynches did exactly what Mr. Smith did. The only thing is that they had the benefit of getting the insurance policy assigned to them, so they were provided the information that they wouldn't have had otherwise, because Mr. Smith's, there's no evidence that Mr. Smith's insurance agent knew about the special FEMA designation. The reason the Lynch's agent knew about that is because they just took over Mr. Delacosta's policy, right? All they did, exactly, all they did was say, actually, they did even less than Mr. Smith, because they didn't even go looking for their own insurance, they just had the policy assigned to them. Mr. Smith is told, property's in a flood zone, it's flooded once, it was slight. Mr. Smith gets an inspection, he did not waive the inspection period, he gets an inspection, and then the inspector says, house looks fine to me. He moves forward, he gets an insurance quote, he says, well, I've never paid for flood insurance before, but this looks reasonable, I'm gonna move forward. He's done his due diligence, and I think instead of talking about what each person subjectively did, I think it's important to come back to what Johnson says we have to do, which is a buyer has to have ordinary diligence in discovering information if it's a negligent misrepresentation. It's
I have a question, because you said that the existing flood policy was assigned,
to the Lynches.
which I've never heard, because every time I'm familiar with an insurance company, they say, we don't assign policies, get your own policy. Are you saying they assign it?
Yes.
Almost like there's a conspiracy here?
No, it's my understanding that because of the fact that,
The Lynch's had the policy assigned from when they voted.
yes, and because it was a
Not your
special,
client.
exactly. So the Lynches had the prior owner's policy assigned to
I've never
them.
heard of that happening, but maybe 20
And
years
usually they
ago.
say no.
Right, but this is a special policy. So we've provided in the record, there's, I can't remember what document it's in, but I can certainly look.
They gave the benefit of the lower rate.
It's not a lower rate, it's, you can only insure one of these severe repetitive loss properties with one type of insurance, and that's the citizen-specific insurance
The
that,
Lynch had this special policy.
yes, and that's why it was able to be assigned, is my understanding.
And your client, do they have a special policy?
No. So let's take a step back.
Yeah,
So
go ahead.
the Lynches buy the property from Mr. Delacosta. This is far before Mr. Smith is involved, right? The Lynches find out this information when they get the insurance policy assigned to them, because the insurance, it's the same policy, they've got it noted that it's a severe repetitive loss. They then buy the property subject to that knowledge. A couple years later, they sell the property on to Mr. Smith, who's unrelated to this transaction, and they don't assign the policy. He just gets a quote for his own policy and isn't advised of the special flood hazard or the insurance of the
He
history.
had his own policy, his agent didn't tell him?
No, because it's not a matter of public record. In fact, it's federally protected information.
Yeah, no, so in other words, the agent did some more due diligence, and hey, I just found out, and by then they had to close it.
My understanding is based on what the insurance agent from Mr. Smith told him after they discovered it, is that it can only be discovered in underwriting after the fact. So that's
a
exactly.
question of fact, maybe.
Okay,
Maybe there's more.
I'm gonna let you answer Judge Williams' motion, but then you'll need to wrap.
Okay, no problem,
I
thank you.
understand.
Okay,
We've used your time.
okay, so I'm just gonna, just one thing, and it's the Florida Supreme Court's, statement in Gilchrist that just says the law appears to be working towards the ultimate conclusion that full disclosure of material facts must be made whenever elementary fair conduct demands it. And I think in this case, given the Lynch's knowledge, elementary fair conduct would have been to provide Mr. Smith the same information. Thank you.
Okay, thank you both. All right, all right, we're gonna take our next case, Corbin versus McDaniel.
Thank you.